All right, everybody, let's begin. It's now time for our third panel, titled Deconstructing the Administrative State, How Soon is Now? It's Problems with Agency Adjudication, ALJs, and the APA. Before we introduce our lead speaker and the other panelists, I just want to introduce the subject really briefly. I went back and looked at the 1941 Attorney General's Committee report, which Bill cites in his fine paper, on how they describe the work of the ALJs. And it's interesting, they talk about the need for impartiality. This is in 1941, the need for impartiality in agency adjudication. They say, to accomplish this, it is necessary that the evidence be heard and the facts be reported to the agency head by an official who shall command public confidence, both by his capacity to grasp the matter at issue and by his impartiality in dealing with it. If the initial decision, which may dispose of the case or be the statement of it from which appeal may be taken to the heads, can carry a hallmark of fairness and capacity, a great part of the criticisms of administrative agencies will have been met. Well, now, more than a half century later, we once again find ourselves debating the role of ALJs within the agencies and in applying the law. A recent Wall Street Journal article suggested that the SEC, for example, has a 90% win rate in cases that it brings before its own ALJs, and only a 69% win rate in federal court. On the other hand, a forthcoming study by Erskov Velikonja suggests that the district court win rate is basically identical, that the SEC wins roughly 90% of its cases before either the federal judges or the ALJs. And now we have constitutional questions surrounding ALJs. A couple of recent courts in the 10th Circuit in the Vandermeer case, the court declared SEC ALJs to be unconstitutionally appointed. In the D.C. Circuit, meanwhile, in the Lucia case, the court found them to be constitutional, but I think now has set it for rehearing en banc on May 24th. And all this is against the backdrop of reinvigorated debate in the courts, in Congress, in the executive branch, and in books like that of our luncheon speaker, Professor Hamburger, reconsidering the administrative agencies as a matter of first principles. And so it's my great pleasure then to introduce today's speakers, all of whom have great expertise and experience on these issues. I'll introduce them one at a time as they speak, but we'll begin with Professor Bill Funk. He's the Lewis and Clark Distinguished Professor of Law at the Lewis and Clark Law School. He's the author of American Constitutional Structure and co-author of one of the leading administrative law casebooks. He's published numerous articles on administrative and environmental issues, including in publications like the Harvard Journal on Legislation and the Duke Law Journal. Before coming to law school to teach, Professor Funk was Assistant General Counsel at the Department of Energy. Bill, please.
Well, it's a pleasure to be here, and in as much as this is the Antonin Scalia School of Law, I'd like to say that my first job after clerking was working for Antonin Scalia in the Office of Legal Counsel, where we became actually pretty good friends. And he was the reason I went into the professoriate. I'm not sure he was happy about that, but he was the reason for it. So, and I've also noted that today his name has been brought up by three different speakers, two conservative speakers who trashed him, and one liberal speaker who praised him. So it's sort of a strange situation. I will also refer to him in my paper, but the thesis of my paper is that the original meaning and interpretation of the Administrative Procedure Act regarding when adjudication is required to be carried out pursuant to the APA has been eroded in favor of non-APA adjudication. And non-APA adjudication provides less protection to parties, private parties appearing before the agency, and at least arguably provides a benefit to the agencies. So this paper then asks whether this is a problem, and guess what I think it is, and then what might be done about it. So the first question is, what does the APA actually say? And the APA says that an adjudication under the APA is required if the adjudication is required by statute to be determined on the record after opportunity for an agency hearing. If the adjudication falls within this language, then the APA provides a close to trial-like procedure. It is not quite a full trial. Discovery isn't guaranteed. It's optional. It can be done or not. There's various differences. The original idea would be that it would be quicker and faster than a court case, but that it would provide the basic elements of a trial that you would find in a court. In addition, the APA adjudication requires what now we call an administrative law judge, which at the time was called a hearing officer, and that, since the beginning of the APA, and one of its innovations, was to make the now administrative law judge, then hearing officer, essentially independent of the agency for which he worked, or she worked, although historically it was all he's because of the veterans preference provision that governed how they got appointed. So they were independent of the agency because the agency could neither reward them by promotion or bonuses, nor punish them by downgrading them or firing them. It was a very tedious procedure to try to remove an administrative law judge, and has almost never occurred. If, however, this language did not apply, then the APA provides no particular procedure, and it is up to the agency merely to comply with due process, and the flexible due process that we've come to know and love. And in particular, it doesn't require an administrative law judge, and indeed, agencies have used as what we now call administrative judges, or AJs, as opposed to ALJs. And these people, in prosecution cases, the judge can actually be somebody who is a prosecutor, not the prosecutor in that particular case, but a prosecutor who normally tomorrow will be prosecuting somebody else for the same type of activity, can be a judge the day before in a case on all fours with it. So that's the kind of situation that we're talking about in terms of between these two different options. So the history of this language and its original interpretation. The original meaning, as reflected in the Attorney General's manual, which came out right after the APA, and which, as has been acknowledged by some scholars, is not exactly an unbiased form of legislative history, but reflects more or less the executive branch's interpretation of the APA, which would mean favorable to agencies. But nevertheless, the original interpretation contained in the APA, contained in the Attorney General's manual, was that a hearing would be required to be follow the APA procedures if it was an evidentiary hearing and a statute required it. That was all there was to it. Does a statute require a hearing, and is that an evidentiary hearing as opposed to a legislative type hearing? And if so, that meant that it would be a APA adjudication, and then there were some exceptions specifically lined out in the APA that would not apply to it. Those have never been problematic in terms of their application. Well, the Supreme Court in Wang Yang Sung in 1950 even took this a little broader and said that whenever due process required a hearing, that hearing would be done under the APA, federal case, obviously. And so therefore, this potentially broadened the scope of the APA, in fact, sort of inconsistent with the legislative history, which went to some lengths to explain that it was a statute that would have to require the evidentiary hearing, not just the Constitution. But the Supreme Court, guess what, was a little broader than the statute here, and did what I thought was a good idea and extended it to any case that involved due process. Well, this broad original conception has been eroded over the years through what I call the misapplication of various Supreme Court opinions, 3 in particular. We've heard mention of Florida East Coast Railway earlier today in talking about formal rulemaking, and that indeed it sounded the death knell for formal rulemaking by saying essentially that a statute had to use magic language, in essence, in order to, in fact, require formal rulemaking. Now, the language under the APA that requires formal rulemaking is virtually identical to the language that requires formal adjudication under the APA. And so it's not crazy to think that, well, if there's this presumption against formal rulemaking, there's a presumption against formal adjudication. But that would be a false application because, one, again, the Attorney General's manual back in the day, and actually the legislative history of the APA in Congress, indicated that even Congress and the original Attorney General's manual understood there was a distinction between rulemaking, which mirrored the legislative process, and adjudication, which mirrored the judicial process, and that the one that mirrored the judicial process the presumption should be in favor of formal adjudication, whereas the presumption in rulemaking should be against it, even way before Florida East Coast Railway. And then the Supreme Court in Florida East Coast Railway made that very point. That there was a distinction between rulemaking and adjudication, and this presumption against formal process, trial-like procedures, should apply only in rulemaking. That's the presumption. Against presumption should be in favor otherwise. So to the extent that some courts later read Florida East Coast Railway to undercut when APA adjudication should apply, that would be misapplication. Matthews versus Eldridge talks about flexible due process. Well, clearly, the due process in Matthews v. Eldridge doesn't require APA adjudication. Now, how can that be? How can APA adjudication be required in places where Matthews versus Eldridge wouldn't require it? Well, Matthews versus Eldridge is a federal case, but the adjudication it was considering was a state adjudication. As a state agency that was acting as the initial finder for preliminary determinations for disability determinations. So it wasn't even a federal agency whose adjudication was taking place that was being questioned. So the APA never came up. But again, this case is because of flexible due process, don't need formal adjudication, has been used as a justification for undermining use of the APA's adjudication. And then finally, Chevron, which, of course, everybody has to refer to, or else we wouldn't be here. So there, the court says you defer to an agency's interpretation of ambiguous statutes, which it's supposed to administer. And several lower courts, and it is really now sort of the norm in the courts that have considered it, have said, well, when an agency looks at its statute and it says there's a hearing, and they say, well, the hearing, what kind of hearing? That's ambiguous, and therefore we defer to the agency's reasonable interpretation. And guess what? The agency always interprets it to say no APA adjudication. Right? So again, this is a misapplication because the statute that is ambiguous is not the agency statute, it's the APA. And the APA is administered by no one agency, and the court has said time and again that when a statute is of general applicability applied by all sorts of people, there's no Chevron deference to any agency. It's the court who gets to decide. So all three of these cases are misapplications in eroding the APA adjudication requirement. So is erosion a problem? Well, some people say formal adjudication is becoming too judicial. It's sort of the same idea as ossification of rulemaking. You know, it was originally thought to be a fast, quick, easy, better way to do lots of kinds of adjudications rather than having every case be a quote-unquote federal case. But that said, nevertheless, it has within its scope the ability to be quite judicial or not. But some people think it's too judicial. However, scholarly critiques have not been that favorable in favor of reducing APA adjudication. Most of the people who've looked at this have come out in favor of saying we need more APA versus non-APA adjudication. And the Administrative Conference of the United States for years attempted to urge agencies to use formal adjudication rather than non-APA adjudication. Until most recently, last year, they came out with a recommendation that I will discuss a little bit later, in which they sort of accepted as a fait accompli that agencies were, in fact, going in favor of non-APA adjudication, notwithstanding ACUS's early attempts to get them to do otherwise. Why do agencies desire to avoid APA adjudication? And the answer is they want to avoid the use of ALJs. And there's both legitimate and illegitimate reasons for this. The legitimate reason really is that ALJs are beholden to no one. They are, if we talk about headless branches, they are headless branches, or headless roots, or headless trees, or something. Nobody's in charge. Nobody can do anything to them. Now, you could say the same for federal judges, all right, Article 3 judges. But Article 3 judges don't get appointed the way ALJs get appointed. And it's a different career route, and the Constitution sets up a requirement that nobody can supervise federal judges. There's no such requirement for ALJs. And there's enough evidence with the number, especially the number of ALJs, that there's some who should be subject to supervision, but they aren't. And so that's a legitimate concern of agencies. The illegitimate reason is they don't have any control over them, and they would like to have control over them. They would like to know that these people are their friends. And indeed, if you have non-ALJ adjudications, then the judge in that is appointed by the agency and is rated by the agency, supervised by the agency, rewarded, promoted, demoted, whatever, by the agency. So they have, in that sense, much more control. So that's what I call the illegitimate reason. Now, defendants are subject to judicial officers with none of the protections of the APA in a non-APA adjudication. We're talking about is erosion a problem? It means defendants in agency cases are getting less protection. The judicial officers who can be prosecutors, as I've mentioned already, and they, as I mentioned, they're rated and rewarded by the agency. So this is something that could be viewed as leading to some sort of partiality as opposed to impartiality. So what's to be done? Well, first action, no action alternative. Anybody here is an environmental lawyer knows we start off with the no action alternative. And this would be saying, well, actually, this is the wave of the future. You know, we really don't want a lot of formal adjudication. It's faster, easier, and we'd like people to be subject to supervision. And there's even a DC Circuit case that deferred to an agency's decision to go with non-APA adjudication as opposed to APA adjudication, made language about sort of like this. I mean, it was a reasonable interpretation that the agency made because this was faster, simpler, and you know, the agency's not going to really do things bad after all. This is a different DC Circuit than today. Another alternative, if we're going to pass the no action alternative, is to substitute Article 3 courts for administrative adjudication. Professor Hamburger, for whom you will hear later today, will in essence make this case, I think. And it certainly would be one way to deal with it, except that, at least as I understand Professor Hamburger's argument, it wouldn't deal with denial of government benefits or taking away government benefits, because benefits aren't property rights, at least under an originalist conception, and so therefore they wouldn't get protected by this requirement to have it done by Article 3 courts as opposed to administrative adjudication. But needless to say, this is a relatively radical approach to say that no administrative adjudication that affects property or liberty. So I'm going to skip over that one and try something else. Well, we could adopt ACUS's recommendation made last year. As I said, it sort of accepted as a fait accompli that the agencies were going in favor of non-APA adjudication. So ACUS came up with a list of best practices for non-APA adjudications. And guess what? They are exactly what's in the APA for APA adjudications, except no ALJ, no administrative law judge. Still have the administrative judge, the person who's subject to control by the agency. Well, you know, that would be an improvement, I guess. But the question is, if the real problem with this erosion is the lack of that independent judge, then this really doesn't get to the core. We could adopt Professor Kent Barnett's suggestion. He wrote a paper in which he argued that agencies really have misconstrued the costs and benefits of APA adjudication and thought that APA adjudication was too costly from the agency's perspective. And he wrote an article which tried to show how there were all these benefits to the agency from using APA adjudication and trying to convince them that it was in the agency's own interest to use its Chevron deference to err or to interpret its language in favor of APA adjudication rather than non-APA adjudication. You know, that's not the way the agencies have been going. I don't think they're going to be convinced by his cost-benefit analysis. So he wrote another article in which he argued that, well, actually, it's a violation of due process to use a non-APA adjudication because these judges who are subject to rating and approval and so forth by the agency creates an unconstitutional possibility of appearance of partiality. That too would be a fairly radical approach. He's made some good arguments why it's not so radical in light of some recent Supreme Court cases, but I'm doubtful. So, another possibility. Have the Supreme Court correct the lower court's interpretation. Go back to the original meaning of the APA. This actually, you know, is a fairly likely possibility if a case could be gotten to the Supreme Court. The concern with Chevron that we've seen in the Supreme Court, they wouldn't have to overturn Chevron, but they could certainly cut back when it could be applied and cut it out in terms of deferring to agencies with respect to when APA adjudication is required. Another solution would be to have Congress make explicit when APA adjudications are required, to clarify this. That would also be a nice, simple, clear solution. And again, we have all these reform bills in Congress, and this might be a great time to do it. But guess what? Not one of the reform bills that have been introduced would do this. So that's, you know, where's Mr. Flores here? You know, we could try to change that, get them to put that into the bills. We could adopt Professor Scalia's suggestion. Well, when Antonin Scalia was a professor, he wrote an article called The ALJ Fiasco, a Reprise, in which he just lambasted in the way Justice Scalia did later about other things, the way that ALJs were appointed and not supervised. And he just thought this was awful. And so his solution was to have the law change and have ALJs be subject to the supervision of the agency. The problem that the agency might use this supervision in improper ways, he thought was, you know, not very realistic. He thought that, you know, the tradition of a judge being independent would be followed, and so we shouldn't worry about improper influence. Okay, I don't think so. So then we have this last one, variations on a central panel, which is that central panels exist for OSHA. We have OSHRC, the Occupational Safety Health Review Commission, and it has ALJs who aren't subject to even the agency, but they're subject to supervision by that central agency. So there's no problem of partiality. They don't have a stake in the people they're subject to, aren't vested in how the case should come out. So that would be a solution for ALJs, but not much for AJs. That is, agencies wouldn't like that. They would oppose that. They might like the idea of having ALJs subject to their supervision and wouldn't oppose formal adjudication in those circumstances. So that's my paper, and thank you.
All right, our next panelist will be Jennifer Mascot. She's an Olin Searle Fellow in Law, Georgetown University Law Center. Previously, she was a professorial lecturer in law at the George Washington University Law School. It's nice for you to finally come to the right George University. She served as a law clerk to Justice Thomas and to Judge Brett Kavanaugh. Prior to attending law school, she held various staff positions at the House of Representatives and the U.S. Senate.
Great. Thank you, Adam, and thank you to the Center for hosting the discussion today, and thanks to Bill for presenting your paper on ALJs. I very much enjoyed reading it and learned a lot. And I agree with Bill to a large degree about the improper erosion of formal adjudication as required by statute in the APA. Specifically, I agree that the Attorney General's early conclusion that any statutory evidentiary hearing requirement triggered on the record adjudication was persuasive. As Bill said, it was a roughly contemporaneous statement against the executive branch's own interest in maintaining flexibility to engage in informal adjudication. Also, Bill, in my view, persuasively argues that circuit courts have been improperly delegating Chevron deference to agencies to determine their own procedural requirements under the generally applicable APA. As Bill observes, the Supreme Court seemed a little more skeptical towards Chevron in recent years, and so perhaps if this issue did come up before the court now, the court would find the circuits have been improperly deferring to agencies on their APA interpretations. And I don't know, perhaps maybe this is too much of a stretch, but perhaps one could even argue that King versus Burwell's major questions exception for issues of deep economic and political significance should apply. Maybe it should bar deference when agencies are trying to get power to determine on their own what types of procedural constraints should bind them. So for these reasons and others, I agree with Bill on his statutory points. Where I start to diverge from Bill's draft paper, though, is on some of his suggestions or implications that we need more formal adjudication, not just because the APA requires it, but because as a matter of basic constitutional fairness, ALJs need to be impartial and maybe independent from executive actors. And I think this view raises some problems. First, Bill suggests early on in the paper that some of the factors that might give us confidence that ALJs are impartial relate to the ways in which they are selected and supervised. And so, for example, right now they're not treated as officers subject to Article 2 appointments constraints. Also, the Merit Systems Protection Board is the only entity with the power to fire ALJs, and only for good cause. And so because agency and department heads have very little role in supervising ALJs, or sometimes even in selecting them, perhaps they're properly being sheltered from bias and political power. But as Adam mentioned, recently circuit courts have questioned whether the way we select ALJs is even constitutional. Under the Article 2 Appointments Clause, inferior officers, as you likely know, have to be selected in just one of four ways: by the President with Senate consent, the President alone, a department head, or a court of law. And in December, also as Adam mentioned, the 10th Circuit held ALJs within the SEC are inferior officers subject to Article 2. Last August, the DC Circuit had concluded the opposite, and of course it's scheduled to reconsider in May, late May, the earlier August decision. I think the principal disagreement between the two circuits seems to center on one specific element of the Supreme Court test for determining Article 2 officer status. Current Supreme Court doctrine says only officials with significant authority qualify as officers. And significant authority can be measured based on the importance of the issues handled by an official, how much discretion an official has in making decisions, and whether statutes explicitly assign tasks to that official. What's in dispute, however, is whether the Supreme Court also ties final decision-making authority to officer status. And so since 2000, the DC Circuit has concluded that officer status necessarily includes the power to reach final decisions, although over some strongly worded separate opinions from Judge Randolph, who disagrees. And so if the DC Circuit sitting en banc this May comes to agree with Judge Randolph's view and reverses its panel decision from August, then at that point, two circuits would have ruled against the government on an important issue, making the case worthy of possible Supreme Court review. And then even if, on the other hand, the DC Circuit continues in its approach, there then would continue to be a circuit split, which would also make the case possibly worthy of Supreme Court review. And I think if the Supreme Court eventually concludes that ALJs have to be appointed under Article 2, this really would seem to cut against some of the apparent impartiality protections that Bill's analysis seems to hinge on. Specifically, a determination that ALJs are officers would enable and actually even require political actors to have influence over both the selection and the possible removal of ALJs. So if we take the removal point first, as Justice Breyer pointed out in his dissent in Free Enterprise Fund several years ago, the court's bar in that case on double for-cause removal protection suggests that finding ALJs to be officers may mean ALJs can be subject to at most one layer of removal protections. The majority opinion indicated maybe its prohibitions on double for-cause removal limitations shouldn't extend to adjudication, but I think the court in general seems headed toward even more of a formalist, democratically accountable view of executive branch supervision. And so by its terms at least, the arguably bright line rule of free enterprise fund would seem to encompass ALJs if they are in fact officers. Because right now, as I mentioned before, they can be removed only for cause by the Merit Systems Protection Board, which is itself subject to another layer of tenure protection. So something about this structure may have to change if ALJs are in fact officers. Also, Article 2 appointments requirements presumably would subject ALJs to selection by an executive authority. Now, by its terms, Article 2 permits Congress to choose whether inferior officers should be appointed by the President, department heads, or courts of law. It does not expressly limit Congress's choice from among those options, and the Supreme Court has not in any way banned all inter-branch appointments. So Professor Ken Barnett, this is another one of his proposals, he suggested maybe therefore the answer, if ALJs are officers, we can address impartiality concerns through an inter-branch selection structure where the DC Circuit would appoint ALJs. But I think there are multiple potential difficulties with that proposal. First, whether one believes there is a unitary executive authority or just a more general duty of supervision, it's hard to see how there's any meaningful executive branch supervision of ALJs if they're appointed and then presumably removed by the DC Circuit. And then I think Professor Akhil Amar has made a persuasive case in his article on intratextualism that actually the best clause-bound reading of the Appointments Clause is to empower authorities just to pick their own subordinates free from the burden of Senate confirmation. And early practice seems to bear this out, because at least in the very beginning, the only officers appointed by courts of law were their own clerks. So if the implication of ALJs as officers erodes impartiality values because ALJs would be hired and removed by political actors, does this mean the court is going to have to narrowly construe the Appointments Clause to maintain fairness? And I don't think so for a couple of reasons. First of all, because one of the core aims of the Founders' Appointments Clause requirements themselves was to ensure transparency in selecting government officers. They thought if a particular actor was responsible for appointing officers, there'd be accountability to pick an excellent candidate, because if the officer performed badly, it would be clear who to blame, and so there'd be democratic accountability, discouraging patronage or other inappropriate selection practices. So I think the clarity of a department head or the president appointing ALJs is a form of accountability in and of itself. And then Article 2 gives Congress the power to create officer positions by law. So perhaps that by law stipulation there includes the power for Congress to at least give some qualifications about how ALJs need to be selected. So perhaps some of the merit-based requirements that they're subject to currently would still be okay, even if they are Article 2 officers. But if even after all that, we think appointment of ALJs is too problematic for fair adjudication of people's rights, I think perhaps we should give more consideration to Professor Lawson and Professor Hamburger's suggestions that agency adjudication is improper for the evaluation of liberty and property rights under the historical meaning of those terms. And Bill mentions this approach is radical, but I want to ask, is it actually? Because first of all, the Lawson-Hamburger approach does apply just to a particular class of cases. It wouldn't apply to adjudication of government benefits and privileges or any other issue not involving deprivation of a historical liberty or property interest. Now, of course, the Lawson-Hamburger approach would involve many more cases reaching Article 3 courts. But is that necessarily a bad thing? You know, whether one has held these concerns for just a few months or for a decade or more now, many scholars and experts currently are contending that they have concerns about the possible overreach of executive power. And so if one has that concern, wouldn't it be appropriate to ensure that a separate independent branch of the government has the authority to decide cases involving liberty and private property? So I think to sum up, in many cases where agencies are just allocating various government benefits, at least as a matter of first principles, there would not be a due process or Article 3 problem with a properly appointed Article 2 officer following whatever procedural requirements Congress decides to impose. But where historical liberty and private property interests are at stake, even the impartiality protections available through formal adjudication just are not enough. ALJs lack lifetime tenure protection and proper appointments procedures. And so I think the pending Article 2 cases on the SEC reveal yet another constitutional ground for reconsidering whether agency adjudication is the proper forum for evaluating deprivations of property interests.
Thanks, Jen. And in addition to Bill's very fine paper for today's conference, Jen has explored these issues in greater length in her own paper that's forthcoming in the Stanford Law Review next year, titled, "Who Are Officers of the United States?" Our third speaker is William Crowley. Will is Senior Vice President of Legal and Public Advocacy for the Foundation for Individual Rights and Education, that are known as FIRE. He's edited the second edition of FIRE's Guide to Due Process and Campus Justice. He's co-edited the second edition of FIRE's Guide to Free Speech on Campus. Bill?
Thank you so much, and thank you for having me. My normal audience in speaking in that capacity for FIRE are hostile general counsel for universities across the country. So you are a welcome respite in some respects and a much more terrifying crew in others. I realize that it's an honor to be on this panel, and I also realize I am swimming in the deep end of somebody else's pool. So to just preface my remarks like that, I want to say thank you to Bill for the excellent paper from which I learned a lot, and likewise to Jen, and I'm sure from Beth and Adam as well. I have to note at the outset, my concern and FIRE's concern is one step removed. Certainly my expertise is at least 2 steps removed, but my concern here and FIRE's concern with regards to administrative law and due process considerations arises particularly from the Federal Department of Education's Office for Civil Rights, OCR. That's the federal agency responsible, some of you may know, for enforcing federal anti-discrimination statutes like Titles 4, 6, and 9, outlawing discriminatory harassment on a number of protected class statuses, including Title 9 on the basis of sex. What I want to talk about here briefly is some of FIRE's concerns in those respects, and then point out the way in which OCR has picked and choose from APA adjudication to justify what FIRE believes and others believe is a reduction of due process for individual students, notably not institutions themselves. So to preface, I'm dealing with a different kind of arena, but perhaps it'll be of interest. In April of 2011, and that's 6 years ago this month, OCR issued a quote-unquote Dear Colleague letter posed as a substantive guidance document that dramatically limited the autonomy of recipient institutions, i.e. colleges and universities that accept federal funding in some form, including Pell Grants. And this means, in practice, the vast majority of both public and private institutions nationwide. The Dear Colleague letter sought to suggested itself as guidance, but really imposed new mandates on how institutions could respond to allegations of sexual harassment and sexual assault. Notably, for FIRE, a civil liberties organization concerned not only with due process but also freedom of speech, there are considerable tensions in how the Office for Civil Rights has defined sexual harassment. We think quite often it is done so in a way that implicates First Amendment speech on campus, but I'll put those aside for now and focus specifically on due process questions. Most notably, the 2011 Dear Colleague letter required institutions to use the preponderance of the evidence standard, the judiciary's lowest, in adjudicating these allegations. It also strongly discouraged cross-examination in university proceedings, and it provided both parties with the right of appeal in case of a loss. And we're talking again about individual adjudications run by colleges and universities. OCR based its requirements on the agency's reading of 34 CFR 106.8b, that's one of Title IX's implementing regulations, which requires institutions to, quote, adopt and publish grievance procedures providing for prompt and equitable resolution of student and employee complaints of sexual discrimination. Again, prompt and equitable resolutions. OCR, in FIRE's opinion, is hanging an awful lot on the word equitable, using equitable as a peg to impose heretofore unannounced requirements on university adjudication procedures. In May of 2011, I wrote a letter to OCR on behalf of FIRE expressing grave concern about the impact of the DCL on campus civil liberties, most particularly student due process rights. In the years since, other groups have echoed FIRE's concerns, including the American Association of University Professors, the American College of Trial Lawyers, the American Booksellers Foundation for Free Expression, the Alliance Defending Freedom, the Defending Dissent Foundation, and many other groups from across the political and ideological spectrum, including notably sizable groups of law professors from both Harvard and the University of Pennsylvania. Unfortunately, our concerns have sadly proven prescient. Colleges and universities have scrambled to meet OCR's new mandates in the 6 years since, and scores of students, both accusers and accused on campus, have filed lawsuits against their institutions alleging breaches of contract, Title IX violations of both procedural and substantive due process rights, and more. The lawsuits are still working their way through the courts, but the legal landscape is shifting quickly and oftentimes in seemingly contradictory directions. no one seems happy, as the general conclusion, with the 2011 Dear Colleague letter. Fire believes the reason no one seems happy with this letter is because it was adopted without going through substantive notice and comment rulemaking as required by the Administrative Procedure Act. In June of last year, we filed a lawsuit, or we sponsored the filing of a lawsuit to be exact, on behalf of both an individual student and an institution. The claims for standing vary for each, obviously, and I encourage you to check out the complaint and the subsequent briefing, which is available on our website, www.thefire.org. The case is now in limbo, given the change of administration in District Court and the District of Columbia. Two points perhaps of interest to Professor Funk's excellent paper. First of all, OCR justified its preponderance of the evidence requirement in large part by noting in the footnotes of the 2011 Dear Colleague letter that OCR also uses a preponderance of the evidence standard in its fund termination administrative hearings. Per the Title IX regulations, which adopt Title VI regulations, these hearings are governed by 5 U.S.C. Section 556D. Fund termination provisions in that regulation, quote, must be supported by and in accordance with the reliable, probative, and substantial evidence. As OCR noted in the 2011 Dear Colleague letter, the Supreme Court has interpreted that standard as a direction to use the preponderance of the evidence standard, Stedman versus SEC. Setting aside whether the use of the preponderance standard for fund termination hearings following accusations of institutional violations of Title IX has or should have any bearing on the use of the standard in hearings for individual students accused of sexual assault, it's interesting to note that 556D also allows parties to, quote, conduct such cross-examination as may be required for a full and true disclosure of the facts. This stands in stark contrast to OCR's Dear Colleague letter, which strongly discourages cross-examination in those individual hearings. In other words, I think the agency is picking and choosing from the APA adjudication context which procedures it would like to use, citing those procedures as justification for an entirely different context in individual students, and ignoring the ones that might provide for some procedural safeguard for those students. Second, and this is just interesting in conceiving of how agencies interpret due process protections for themselves, which may have some bearing also on Professor Funk's paper. In October of last year, OCR issued an unprecedented resolution agreement with a small private college in Delaware, Wesley College. I have a fairly encyclopedic knowledge of schools and universities after spending a decade at Fire, but I had not heard of Wesley. And now I know very, very much about Wesley. In this case, OCR issued a resolution agreement finding that Wesley had violated Title IX by imposing procedures that did not sufficiently protect the due process rights of students accused of sexual misconduct, and that violation ran contrary to the requirement of prompt and equitable hearings. That is to say that equitable in OCR's determination both requires a lowering of procedural due process safeguards with regard to the standard of evidence and the discouragement of cross-examination, but there is a line that at some point OCR can go too far and violate that equitable requirement by stripping too many procedural protections from an accused student. In this case, specifically, the student was expelled without a hearing, without being notified of the proper procedures for disciplinary proceedings, without receiving any of the evidence against him. The expulsion, remarkably, was issued just a week after the student learned of the charge against him. Apparently, this was common practice. OCR reviewed disciplinary hearings for similarly situated and similarly accused students over the past several years and found that 10 of the 12 complaints that the college received between August 2013 and 2015, the conduct process was conducted in a matter of days. So kind of a shoot first, ask questions never approach. The Wesley College agreement, again, was to our knowledge unprecedented. It indicates that some denials of due process are too much even for this agency, which we think has acquired a deservedly bad reputation as being hostile to due process interests. If OCR wants to rectify that use, it's interesting to me to consider after Professor Funk's paper that at the very least it could begin by requiring the full panoply of rights that seem to be contemplated in APA adjudication hearings. So thank you very much.
And our last panelist today is Beth Franklin. Beth is an experienced appellate and Supreme Court litigator who served in high-level positions in the Department of Justice, most recently as Deputy Assistant Attorney General in the Civil Division, and before that, nearly a decade in the Solicitor General's office. She's argued 24 cases before the Supreme Court and many cases in the federal courts of appeals, including the successful defense of the constitutionality of the Affordable Care Act and the government's victory in federal immigration and preemption litigation. Following the old rule, after you beat them, join them. She's now a partner at Covington and Burling. Beth?
Thank you very much, Adam. I really appreciate the invitation to be here today. As one of the few non-academics, it's quite a luxury to be able to step back for a moment and think about some of these bigger issues about due process, particularly as part of the adjudicatory process. Not only as a non-academic, but as a veteran of government service, three times actually, but certainly over the last several years. The first thing I just want to say is a little background or a little perspective as I come here with that background. And then I wanted to talk more specifically about Bill's paper and some ideas I have on that. So the first perspective I just wanted to give was, I guess, a much more optimistic view that I've heard here today. I understand the concern about whether or not ALJs can be impartial based on how they're appointed, but perhaps I need to harken back to Justice Professor Scalia's original idea of, why is there, or do we need to be so concerned about the impartiality of an officer or of an employee or of someone who is making these kinds of decisions within the agency. And I do want to just give that practitioner's experience. Over the years when I've worked in the government, as a litigator, I would deal with individuals who had been involved in the adjudicatory process or, were coming from the agencies. And also I advised many agencies on questions about regulations and adjudication processes that they were proposing. And uniformly, the dedication of the employees in those agencies was not just to the really non-political, often, goal of their agency, but also just to the standards of good government. I think, of course, there are always the very controversial issues out there, and there are always those cases which seem a real problem for the agency in the process or even the regulatory, the rulemaking. But I don't want people to forget about the vast majority of regulations that are unchallenged, that are very important and are administered in a way that don't raise those kinds of problems. So I just want to really say that and commend the federal employees that do that job every day. And one thing that we all have to remember as we sit here, and again, this is very enlightening and refreshing to think about how to solve some of the problems that certainly are important. But in the meantime, somebody's got to make decisions and run the government. And what do you do when Congress made a mistake or, has this lack of clarity? Somebody's got to do something about it. So I want to make sure that we don't demonize people as exercising too much authority or maliciously overstepping their limits. They're charged with doing their job, and they are trying to do that job with a very imperfect statutory framework sometimes that is presented to them. So I think that's one thing that the practitioner in me and the government lawyer in me wants to kind of give as a backdrop for when we consider those. So that leads me to really just complimenting Bill on looking through all of these different options about how to address what he has described as the erosion of the use of ALJs. I learned a lot from his analysis of kind of Chevron and Matthews v. Eldridge and how maybe we got to where we are on what the court and the agency's view is who gets to decide when you need to use an ALJ. I don't know where I come down on some of those, but I do know that where we are now, the solutions that he's talked about are very intriguing, the half dozen or so that he's talked about. The main premise that I come with to considering which solutions and might help us discern when we should have ALJs or not, though, is one that perhaps is not consistent with some of the views that have been expressed here today. To me, one size just doesn't fit all. We talk about ALJs in this very, or agency decision makers in a very generic sense, but they do very different things in different agencies. Indeed, in Jennifer's discussion about the SEC ALJs, I very much agree with her that I think that that issue is heading to the Supreme Court. Whether the DC Circuit and the 10th Circuit end up in agreement or not, but that question of whether the SEC ALJs are officers or employees is one that's going to be ripe for review. But interestingly, I believe it was in the DC Circuit case, there's this amicus brief that I thought was filed in the wrong case when I first saw the title of it. I think it was the Association for Step Horses. It's some association about horses, and they're challenging, or they want to describe what the ALJs at the Department of Agriculture do. And I thought it was really a good reminder of how different ALJs, what different roles they can play. Of course, you know, if agencies are making the decision, they could have ALJs decide just facts, not law. I mean, the government's brief talks about some of the options of what ALJs could do. So I just also want to put that in there. I just don't think one size fits all when we talk about this. And that's why, you know, I have great hesitation sometimes on that, you know, lacquering over everything and making a grand statement like that. One area I just want to throw in the mix here in particular is something that I did not have much experience in my, before I went back to government my most recent time, and I'd been there for years before in the Solicitor General's office. But when I came back, it was after September 11th, and the national security issues that I dealt with were so fundamentally complex and added a whole nother layer to agency decision-making, adjudication, processes. I think there's going to be a lot of action in that area in the next several years. There's been a very long tradition with obviously quite notorious exceptions, but there was quite a culture of, you know, need to know what's classified. There were, of course, I think always criticisms of overclassification that could be well taken. But I have to say, when you're sitting in a room and you're looking at some of this information, you realize, you know, this does need to be classified. That is a very difficult area. And just that's the most obvious and easy example of one size is not going to fit all about processes and how this plays out. I think it also is a good example of how you just can't trust. You know, you have to also have procedural checks in there. But I do think that that is one area that is going to have a lot of action in it. I think particularly in light of the Attorney General's recent emphasis and announcement about more focus on prosecution of leaks, I think there's going to be, you know, perhaps also legislative action. There's various statutory provisions that are up for re-examination. And I think as more information comes out about how various agencies work, there are going to be more questions about that. And then also we have this really interesting experience with the FISA court and the processes that have been developed there, where they are reviewing agency actions that are classified and are not public. And as most of you probably know, in the last legislative or in the last kind of attempt to revise some of that, there was a provision put in to appoint an amici who could come in and give an additional view instead of just having ex parte proceedings. So there's a lot there, I think, that we have to think about as a very practical way when we're thinking about grand principles for administrative law, and realize that in our world today, there are a lot of different roles and that one size doesn't necessarily fit all. So where does that bring me on some of these proposals, how to perhaps address some of the need for due process protections in the administrative process? I guess I would take the easy way out and say there's certainly a combination of these suggestions that would be a first step. The best step, perhaps, would be have Congress say it when they mean it. A clear statement rule of when there has to be an administrative law judge, when there could be a hearing of some lesser degree of due process. There are big decisions and there's small decisions that have to be made by agencies, as many people on the panels this morning have emphasized. And those big decisions aren't always the most complex ones. Sometimes the most complex ones aren't that significant. And so all of that has to be taken into account. I think in our world today, Congress' state of dysfunction is not going to lead to that kind of clarity. For the courts to do it, or for the Supreme Court to go back and clarify what the original meaning that Bill sets forth in the APA sounds like a good ideal, but of course there have been so many statutory enactments since then and actions by Congress that then have been made against a backdrop of judicial decisions that have strayed away from Bill's view of that original language, suggests that perhaps the court doing that would then be giving meaning to statutory frameworks that Congress didn't intend in the meantime. Some combination of these suggestions, I think the best practices, if there's some way to incentivize agencies to have that kind of additional protections as appropriate when due process would call that into significance. Also, I think Professor Scalia's idea of improving the quality of administrative law judges would be a threshold incentivizing mechanism to have them play a bigger role. Again, I do wonder how much who actually appoints the employee brings to bear on their impartiality or not. As Jennifer mentioned, I think there is just this tradition of the role of an adjudicator bringing with it this responsibility to adjudicate fairly. And this is certainly something I think within the administrative world that is not only reserved for those who might be appointed by the head of a particular agency. I also think the idea of some agencies having more of this OSHA model might be worth considering. But I think that we have to realize that different agencies are going to end up needing different kind of models, and that obviously is best for Congress to set that out. And I think if we're dealing with the lay of the land we have now, then to try and set up these incentives, improve the quality of the ALJs, have these best practices, and trying to move towards that where appropriate. I wanted to make one comment, I think, about Will's presentation. I thought it was very interesting. It is, of course, as he mentioned, you're really twice removed because those are universities making those decisions.
Testing, 1, 2.
And it's an area where there's been a lot of development in the past several years. I would say, it's an interesting area because I am also a former public defender. And when you look at these kinds of procedures, we all start thinking of them really as criminal procedures and needing that kind of due process. And yet they're not. These individuals who are accused are still obviously subject to criminal prosecution. And I think it's a very challenging area. And I think that you're pointing out of this recent consent decree where there was some kind of agreement where the school would abide by firmer due process protections even within their realm is very important. I think that is an area where universities certainly would welcome guidance. I think that that's the balance. I think a Dear Colleague letter like that does have this benefit for agencies putting those that are involved with on notice of how they interpret the law and trying to provide some of that guidance. So there is a benefit, I think, to agencies not operating in the dark. It is more transparent to at least put out there those kinds of guidances. So I think there's a balancing there that has to be taken into account. So I think I'll stop on that and turn it back over to Adam.
Thanks, Beth. Thanks, Beth. Before we move on to questions, I just want to give Bill a chance to quickly respond to a couple of points, and I'm particularly interested in your thoughts on Beth's admonition that we shouldn't pursue one-size-fits-all solutions on this.
Okay, but I'm start with Jennifer on the appointments issue. I mean, I view this as being making a mountain out of a molehill. The APA says agencies shall appoint ALJs. All right? So the question is, well, all right, who in the agency? Well, comply with the Constitution would be easy just to say head of the agency. All right, that'll do it. Well, as soon as the first SEC, or actually the Federal Deposit Insurance Corporation case came up, the FTC said, well, we're going to appoint all our people by the head of the agency. They hadn't in the past. Solved the problem. SEC, for some reason, which is the cases that are all going up, just refuses to have the head of the agency do it. They have their head ALJ do it, the chief ALJ. But other than the fact that they'll have all these cases in the pipeline that would have been decided by people wrongfully appointed, going forward, it's an easy fix. Just have the head of the agency appoint the person. So I don't see that as a particularly big deal. Now, the second aspect of them being officers would be, does this trigger the dual for-cause removal protection problem of what we call the peekaboo case, Public Company Accounting Oversight Board case, that said that the PCAOB, it was dual for-cause removal protection because the SEC supposedly had for-cause removal protection, and they were the ones who would remove the PCAOB people. Now, actually, for ALJs, it's a triple for-cause removal protection because to start the complaint, at least by an independent agency, say the SEC, the SEC's members can only be removed for cause. They complain to the Merit System Protection Board, and they can only be removed for cause, and then they can only remove the ALJ for cause. So you got a triple for cause removal thing. But I'm willing to bet all the money in my retirement account, and I'm retiring next week, so that's important. I'm willing to bet all the money in my retirement account that there's no way in hell the Supreme Court will say that ALJs can be removed at will. All right? I have no doubt that which way Chief Justice Roberts will vote, all the Democrats will vote, and I can't speak for Justice Gorsuch or Thomas, but I'm pretty confident about Justice Alito too, that he won't go that route. So it's the United States versus Wiener, the original case that distinguished adjudication. There was no statute requiring these people to be only removed for cause or claims commission. But all they did was adjudicate, and the Supreme Court said, well, they can only be removed for cause, absent a statutory requirement for it. So I just think that's an easy fix, both, whether, even if they're officers, that they're officers solely engaged in this adjudicatory function. That will make a distinction. So that's my response for Jennifer. I'm going to turn to Beth because I'm going to ask Will a question. But on the more optimistic view, there was a study done some years ago in which they interviewed both ALJs and AJs, those are the people who don't have protection. And they were both asked, how independent do you feel? How much do you feel the agency is trying to affect you? And the ALJs, had a higher rate of feeling that they were being leaned on by the agency, right, than the AJs, than the people who had no protections. They felt totally independent. That was their self-view, all right? Now, there is a concept of self-delusion, all right? You can delude yourself, all right, and thing. But the real issue here is not so much the agency leaning on people to come to a particular conclusion, the illegitimate thing. It's the idea that these people in the EPA, for example, they use prosecutors to be the AJs in prosecution cases, right? And there's a prosecutorial mindset. I mean, even if it's not your case, even if it's not a case like yours, it's just a different attitude that you come in. One day you're a prosecutor, the next day you're a judge, and that can just help affect you in some way. So that's why I'm not totally optimistic. I agree completely that one size doesn't fit all. In my paper, I deal with it a little bit, not as much as I probably should. Social Security Administration has more ALJs than the rest of the government combined, and it doesn't do any prosecution at all. I mean, it's almost an inquisitorial system rather than an adversarial system. There's no lawyer on the other side. The administrative law judge is required by court decisions to try to find out the truth, which means question the person to try to find the truth. So that's a very different situation. Really, the focus of my paper is where the agency is acting against someone to deprive them of some sort of liberty or property, usually money in terms of a fine or telling an employer what he has to do or can't do. And that's the kind of situation where I'm really dealing with it. And there are some differences, but not that many differences. I mean, the idea that the Mine Safety Health Review Commission has less ALJs than one of the agencies that does prosecutions. I'm forgetting now which one. And it could easily have its own independent commission, or you could create a central panel of judges who handle cases of prosecution from various agencies that could be alike. So that's my answer on the one size fits all. Now, for Will, the real problem, I think, with the Dear Colleague letter is less the substance of it than the procedure by which it was adopted. If there was ever an invalid non-legislative rule that was imposing requirements without going through the right procedural steps, that's it. But be that as it may, my question on the clear and convincing evidence issue, is there any Supreme Court case that said clear and convincing evidence was required as a matter of due process?
There's a case, Addington v. Texas, which talks about quasi-criminal proceedings. And there are also a series of cases that contemplate financial damages. Given some of the interest here, and I take Beth's point very well, this is not a criminal proceeding. But the reality of the situation, I think, just on a practical and pragmatic matter for an 18-year-old or 19-year-old who's been accused of what is, outside of the university context, a felony and one of society's most heinous crimes, is that the implications of being deemed guilty of sexual assault in the college context will follow one around for the rest of his or her career. There's right now a movement afoot amongst the body that handles notations on transcripts to push for mandatory disclosure of sexual assault, expulsion, or discipline, making what is already, I think, a de facto scarlet letter that much more powerful. So I think that the impact is exactly the type of quasi-criminal proceeding that the court has said clear and convincing is appropriate for. I do not think beyond a reasonable doubt is appropriate for the college context.
Well, I do want to save a few last minutes for questions from the audience. If anybody has a question, please raise your hand and the microphone will come to you.
Thank you. This is two questions, actually, for anyone on the panel. The first one has to do with the Vandermeer case, and I think Professor Funk, you're probably the most qualified to answer this. The Vandermeer case, of course, mentions several instances where courts have considered the appointments clause in the past, and it went through a large number to determine what was an officer and what was not. And the courts have also talked about the distinction between officers under the appointments clause and mere employees. And it's notable that the Administrative Procedures Act, when it talks about hearing examiners, future ALJs, only speaks of them as employees. Isn't it true that we should assume that Congress knew what it was talking about and knew of the distinction between officers and employees when it passed the act and defer to that? And my second question is why do we need to go into so much of the process that ALJs use when, in fact, ALJs only write initial decisions or initial recommendations, that the agency on review is not required to follow, and the ALJ's ID is nothing more than a first cut that does produce a record in the case.
Bill or anybody else?
Well, I'll defer to Jennifer on the appointments issue, other than to say that merely the fact that Congress says somebody's an employee doesn't make them an employee for constitutional purposes. So, I frankly think it's a close question whether it's an employee officer, but I'd defer to Jennifer on that aspect. On the question of why do we care about ALJs anyway? After all, it's the agency ultimately who can make the decision, and they clearly have an interest in the outcome of the case, at least the prosecution situation. And I'm glad you asked that, because it's the elephant in the room, which is why do we really care about the ALJs when it's the agency who gets to make the decision? And when I go to foreign countries and talk about our system, this is the thing that they just don't understand. How can you have that? Right? They all have courts. They have labor courts and this court and that court, and they're all separate from the agency. They just don't understand it. And my answer is, I don't know. I had to write something for this panel, so I did this. This will come back to Professor Hamburger, right? And that is to take it out of the administrative agency altogether with the thing. The difficulty is the Supreme Court sort of approved this system, all right? And so we live with it.
And maybe I will step in first with the appointments clause issue. I do think that's a good question. and it really, I think as Bill pointed out, comes down to whether, one thinks it's important to go back to the original meaning. Because, as a constitutional matter, particularly in appointments clause cases, actually, that's one area where the Supreme Court has said that it feels like a very formalist approach is necessary, and that, in these kind of formalist cases with Article 2, that the court's not going to necessarily just defer to even Congress and the executive branch acquiescing in an unconstitutional practice. And just as a historical matter, evidence suggests actually the term employee wasn't even in use at the time of the founding. Oxford English Dictionary indicates the term did not come into existence until the early 1800s. So I don't think Congress possibly could have been consistent with the original meaning at that time. And then if I can just take a quick second, too, to address Bill's point, and this also gets to maybe why do we care? I think it all comes back to this issue of who can authorize the government to exercise power over its citizens. And so the reason why, I really appreciate Beth's point about the dedication of administrative law judges, and I'm sure that many of them are doing, probably virtually all of them are doing a fantastic job, and are great people, but I think we want to be concerned about properly appointing and supervising ALJs, not just if we find evidence that somebody's really manipulating power, but because we want to make sure that the people who are governed have some kind of a say in who governs them. And so I think, even if you move that accountability one step closer, it might sound like a technicality to say, well, now we're just going to slap the SEC's appointment on at the end. Yes, it does sound like a technicality, but at the same time, it's one step closer to the elected president, and then the people who can vote him or her out of office if they are unhappy with the general direction that the executive branch is moving.
I can just add really quickly, your questions actually echo very much the arguments in the government's brief defending the SEC ALJs. And full disclosure, I was involved in the briefing when I was still at the government. I do think that Jennifer really just described it quite well. It's one more step. It is another layer, because ultimately it is the agency that makes that decision. And that's part of the argument why the ALJ isn't an officer under the Landry and the DC authority, where you look at it, and part of what they want to look at, does the individual have binding? Can they bind the agency? Only those would be officers. That's part of the debate in that case. I also think we have to remove, in a sense, this is like a first cut. There is judicial review. And, that is another backstop in our system that's very, very important. So, I think that on the text, that is one of the arguments of the government. And it doesn't have to mean whether or not employee was used at the time of the founding. It was when they, enacted the provision that explained what ALJs were. It says civil service employee. And you would think at that time they knew what an officer was. So. But we will learn from both of these courts of appeals. It's going to be a very interesting spring on this issue.
We're up against time, but one more really brief question.
Really, This is for Mr. Crowley. I have a good friend of mine who was involved with a problem with the Department of Education. This was Grove City College up in Pennsylvania. And of course, they have the Pew Foundation behind them, so they have more money than all the rest of us put together. And the federal government decided that they had to accept federal money. And they went to the Supreme Court twice, insisting that they should accept federal money. And they said no, because if you accept federal money, then you have to have, some federal bureaucrat sit in on your business and run your university for you. And so they refused to do that, and it cost them the time and the effort to step these people back. And finally, the Supreme Court said, no, they do not have to accept your money, and no, they don't have to allow the Department of Education to help run their university. What possible rationale is there for the Department of Education, this administrative boondoggle, to insist that other people accept their money and be run by them? What possible justification?
That's a better question for them than me, I'm afraid. I will suggest that you might find interesting the amended complaint in the lawsuit we're sponsoring against the Office for Civil Rights that goes right to Bill's point about the legality of the Dear Colleague letter under the Administrative Procedure Act, because one of our plaintiffs, the plaintiff that we amended the complaint for, or that the complaint was amended for, is Oklahoma Wesleyan University, which is a small religious school in Oklahoma that has very particular views about its ability to manage itself as a sectarian institution vis-a-vis the Department of Education's requirements. They speak precisely to that tension. So that might be the best source, briefly, to see that.
Speaking of boondoggles, there's free lunch awaiting, and so I do need to bring this to a close. But thank you, everybody. Thanks especially to our panelists.